Disclaimer: the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Hello, welcome to the closing argument section of the University of La Verne Justice Center website. Glad to have you. First, we're going to start with where you are in the trial process. Now that you are at the end of your trial, all evidence has been presented and all witnesses have been examined. It is now time for the closing arguments. The closing arguments phase takes place at the end of a trial and is the concluding argument addressed to the jury or the judge by the parties or lawyers for each side of the case. The lawyers summarize the evidence that was presented during the trial, his or her client's position, and why the verdict or decision should be granted in favor of their client. An effective closing argument ties together all pieces of a trial and tells a compelling story. After this phase is the verdict or decision. The verdict or decision is made by the judge or the jury. The purpose of this phase of the trial is to give both parties a final chance to convince the jury to decide in favor of their side. This is accomplished by framing the issues and telling the jury how each element is the law or is not met by the facts. This is very different from the opening statement, because the opening statement cannot include arguments, but can only summarize the expected evidence. What do you need to accomplish during this step? You should make it very clear to the jury that you've won this case. This requires you going through the law, what burdens need to have been met, and how they were met or were not met based on the evidence presented. Going through each important piece of evidence, if it is helpful, emphasize, if not minimize. Put a bad fact between two good facts. Always surround your case's weaknesses with your case strengths. Next is the process of closing arguments. Closing arguments take place at the end of the trial. The plaintiff presents their closing argument to the jury. The party sums up and comments on the evidence that was presented during the trial in favor of the plaintiff, explaining how the evidence proved the plaintiff's claims. The defense then presents its closing arguments. The defense then responds by answering statements made in the plaintiff's argument, pointing out weaknesses in their case, and summing up the facts that are in favor of his or her client. Since the plaintiff has the burden of proof, the plaintiff is therefore allowed a response. This is the chance for the plaintiff to respond to defendant's points and make a final appeal to the jury. The defense could use whether or not to respond with another closing statement. If so, the plaintiff loses the right to make a second argument. There are different parts that make up a closing argument. Closing argument should include a hook, which gets the jury's attention, a theory or theme, which is one sentence that summarizes your case that should be repeated through your presentation and guide how you represent your case. A summary of facts, which is a few sentences that provide a summary of the relevant facts of the case for the jury to understand what to expect. A summary of law, which is what the jury is going to be deciding and what is your burden of proof or persuasion that the parties must meet. A summary of witness testimony, which produces your witnesses and summarizes what the jurors can expect to hear from them. An argument that explains directly, explicitly, and passionately why you win and the plaintiff has to lose. For example, how is society made better when people like you win cases like this? A request that lets the jury know what you want them to do for you based on the law and evidence, and a conclusion. For example, this is the only verdict that will be supported by evidence. Thank you. This has been an overview of the closing argument section of law. On behalf of the University of La Verne Justice Center, we thank you for your time and hope this information is helpful in your legal matter.